Okay, welcome to this short burst conversation with me on contemporary issues in arbitration UAE, hosted by King's Chambers and the British University in Dubai. My name is Karim QC. I'm delighted to be in conversation with two prominent leaders in their field. I have Professor Masadeh and Dr. Jabbar, and I'll introduce them properly in due course. But before I do that, I just wanted to say a few things. First of all, it's great to be part of Dubai Arbitration Week this year. I know last year it was quite difficult, but it's clear that the last 18 months have been quite interesting in many ways. Whilst personal tragedies have been at the forefront of our minds, the world of arbitration, I think, have had two seismic changes. The first is that at a time when, before COVID, it was said that arbitration was getting a bit stale, the process of arbitration as a dispute resolution mechanism has shown itself to be quite effective and resilient to market changes. And the second thing, I think, is that it has accelerated the use of technology, leading the way compared to national courts for sure. And a fantastic byproduct of all of that is that we have a more sustainable arbitration, or as has become fashionably been known, kind of green arbitration. But let me just talk a bit more about the first point. Now, whilst national courts, when COVID hit, were kind of struggling to see what they can do, by April 2020, 12 of the leading arbitral institutions issued a joint statement pledging that they wanted to ensure that all pending cases would continue and that parties would have their arbitrations heard without delay. And that kind of connects with a lot of our thinking, which is that, there's an old phrase which justice delayed is justice denied. And that connects to something which happened in 2020, which is a talk that I gave in the midst of the height of the pandemic with colleagues all around the world, a virtual talk. And I asked three kind of questions, and we hypothesized what the answers may be. And the first question I asked was COVID the incentive for the use of technology? Would we be looking back at this episode as the beginning of the virtual shift in how dispute resolution was administered? And really, was this the beginning of the virtual judging revolution, which has been advanced by many academics for a while now? Now, in relation to the first point, there's no doubt that throughout all arbitral centres, even national courts, everyone has started to use technology, and good technology. But there are two types of tech, which I think requires different definitions and different consideration. The first is what I call platform technology, and a good example is what we're doing here, but also the technology which helps us to achieve a successful virtual hearing. And a wonderful example of how this is progressing is something that happened to me, which I was involved in recently, which was the use of a 3D camera in a witness evidence virtual room, so that the arbitrator doesn't just see the person's face, but sees their entire person, and so can make determinations about their credibility. But it can be used in the wrong way as well. And I personally remember at the height of the pandemic, when a witness was trying to evade a very difficult question, he pretended that his internet had frozen. The only problem was that the clock behind him kept on ticking. So, that was plainly a bit untrue. But the other type of tech is the tech that assists us as an arbitrator or a counsel in honing our submissions, or fundamentally helps the arbitrator make the decision, and what's commonly been known as assisted decision-making. Now, just to finish, it's probably just worth saying this, that there's no doubt that platform technology, so the stuff that we're using for today, for instance, is now prolific and everyone's using it. But in relation to assistant technology, that's a real game changer. And there's some evidence to show that parties and arbitrators are more open to using these types of technologies since COVID. And you may be surprised to know of the extent of assisted decision-making tools and predictive technology that's already in the market. And in fact, I gave a talk with the professor last year about its use in and the use of AI and technology in arbitration. But in answering those kind of three questions that I asked, a year ago, or perhaps longer, now 18 months in, I think we can look back and we can say that virtual arbitrations have been bolstered by COVID. Plainly, they had to be. And the use of technologies and AI has possibly refocused arbitration to its core positive features, which, we were all taught it was fast, it's supposed to be faster, it's supposed to be cheaper, and dare I say, it's supposed to be greener nowadays. But today, we're here to talk about recent developments and insights into arbitration UAE. And over the last couple of months, there have been certainly many developments. And we're also here to talk about fairness in arbitration. So I'm delighted to be in conversation with two distinguished leaders in their own right. Professor is a professor of law at the Dean of the Faculty of Business and Law at the British University in Dubai. He's published widely in the fields of arbitration, ADR, contract law, and professional liability. He's an experienced arbitrator and a member of the Chartered Institute of Arbitrators and a board member of the International Law Construction Association, as well as a panel arbitrator with various arbitration panels. Dr. Jabbar is a visiting professor, attorney at law and arbitrator, and he's the managing partner of his law firm. He specializes in business law, arbitration, and is on the list of various arbitration centers, including LCIA, SIAC, and the list can go on a long time. Having done my research on him, I've heard that his publication, The Introduction to Business Law, is a really big thing with Lebanese lawyers. So I'm very happy to have him here today. To everybody who's here, there is a Q&A function. We'll try to take some questions at the end if time permits, but Chatham House rules apply. So, Professor, I'll come to you first, if I may.
Yes, please. Thank you. Let me just start by thanking you, Mr. Sam. It's a pleasure to see you here again, joining us at the British University in Dubai, albeit virtually. Hopefully, next time we'll be in person. And thank you, and thanks to King's Chamber for taking the lead on this event. It's a pleasure to be with you as well. And of course, with Dr. Talal Jabbar, he's a prominent arbitrator and lawyer as well. That's just a starting statement that I'd like to say.
Thank you very much.
Yeah.
Lovely. It's very kind of you to say. So, Professor, there's most people are aware of it. A recent decree of this year where a DIAC is to be merged with the Emirates Maritime Arbitration Center and Difc Arbitration Institute into DIAC as well. So I wanted to ask you, because I know you're very experienced in this area, sitting in the region, how will this decree affect the ongoing cases in the Emirates Maritime Arbitration Center and Difc LCIA cases?
Thank you for this question. I think everyone is worried about the impact of the key on the ongoing cases right now. I would assure everyone that there will be no negative impact at all. The rules, although the EMAC, the Emirates Maritime Arbitration Center, and Difc LCIA will not exist anymore, but their rules are still functioning. So basically, the ongoing cases will continue. The only difference is that these cases will be administered by the IAC. So with regards to the arbitration rules, will go on. Nothing will affect the terms of reference, the terms of reference. The procedures are valid and will continue under the old rules until then.
Right. And so, in terms of the arbitration clauses, which refer to the rules, of the two abolished centres, are they valid anymore?
All right, this is different now. We have to distinguish between two phases. These agreements that were made prior to the date when this new decree became into effect. I think this was on the 20th of last September. So basically, prior to the decree, all these agreements are still valid. And basically, the only difference is that DIAC will administer the cases, will step in the place of EMAC and Difc and CIA to administer the cases. So these cases are valid. Now, for the Difc and CIA, it's still not clear on one point, because the Difc LCIA rules allow the LCIA in London to step in and administer the cases in the Difc LCIA. Now, the decree announced, it's obvious in the decree that the DIAC will replace Difc LCIA, because the Difc Arbitration Institute is abolished and Difc LCIA is under the institute. So basically, there are contradictory statements here and there whether the LCIA will have a role in administering the cases in the Difc LCIA, especially the ones that are ongoing right now. For future ones, I'm pretty sure that DIAC will take the role there to administer the cases, and these agreements prior. What matters here is that agreements, arbitration clauses refer to EMAC or Difc LCIA rules prior to 20th September are valid. There's no problem with them. However, for any such an agreement, after the decree became into force in the 20th of September, will be considered invalid. So you risk the arbitration clause. Now,
right.
an agreement that now, today, for example, if you make an agreement that the applicable rules will be Difc LCIA rules, this agreement is invalid. The same with EMAC. So we need to be careful when we draft our agreements that now what we have right now for the new cases or new agreements, what we have is the rules.
Right. So one of the things I was thinking about when I was first reading the decree was that, does it have any effect on the applicable arbitration law?
Yeah. Basically, let me just put it in categories when we say the applicable arbitration law. So basically, if the parties expressed their agreed arbitration law, then the decree will happen. So basically, if the arbitration clause says, for example, that the applicable arbitration law or the seat is the UAE arbitration law, then this will be the Federal Arbitration Law number 6, 2018. If the arbitration clause says Difc arbitration law, then it's Difc arbitration law. There's no problem. Also, if the parties agree that the arbitration will be held in Dubai, or the seat is Dubai, either that the seat or the place of arbitration is Dubai, then the applicable law will be the federal law, the Federal Arbitration Law of 2018. If they agree also in the arbitration clause that the arbitration will be held in Difc, or the seat is Difc, then the applicable law is the Difc arbitration law. Now, and this is the same, nothing changed here with regards to this matter. To that extent, nothing changed. What I think changed is that when parties do not mention the seat or the place of arbitration in their arbitration clause. So the arbitration clause is silent on the seat and the place of arbitration. Here, the applicable arbitration law will be the Difc arbitration law. But keep in mind, previously, this would be the Federal Arbitration Law. Previously, this would be the Federal Arbitration Law, which is 2018. But now this is something new, that the applicable law will be the Difc arbitration law. But remember, this is when the parties agree on the DIAC arbitration rules. If it's an ad hoc arbitration, this is something different. An ad hoc arbitration Yeah, in ad hoc arbitration, this will be the federal arbitration law. But if parts agree for the arbitration to be done under Dubai International Arbitration Center rules, and they do not agree, the arbitration clause silent on the place of arbitration or the seat, then what's new is that the DIFC arbitration law will be the applicable law, not the federal arbitration law. And I think the drafters of the arbitration clauses will need to be careful right now. If they want the federal law to apply, they need to mention them clearly. I'm one of the people who is pro express agreements. Do not leave things to anticipations or something. So if you want the federal arbitration law to apply, then just write it there. It will apply.
Yeah. Okay. Well, one of our attendees has just indicated that that the LCIA issued a statement to say that it would be administrating DIFC LCIA arbitrations on a secondment basis, and for DIAC on an interim basis. So
the main problem here is that we have two statements.
Yeah.
We have the LCIA statement that will continue administering the cases, the ongoing cases, the DIFC LCIA. And we have also the Difc, which says clearly explicitly that DIAC will step in the place of the DIFC LCIA. I think we have to wait for the coming days to see how it will work.
Yeah, well, I'm sure this topic is going to be subject to much discussion throughout this whole Dubai Arbitration Week, with lots of different views. Professor, if I can just move on from the decree then, because I think one of the other issues of the last 18 months, or if not longer, has been about enforceability. And one of the things I just wanted to ask you was, in relation to enforceability, is it possible for the UAE court to deny enforceability on a valid arbitration clause? What's your experience been of that?
A valid arbitration clause. Okay. Well, this would be very rare, to be honest. This would be, I mean, let me put it that way. I think my understanding of the approach of Dubai courts and UAE courts at large is that they are facilitating the arbitration procedures. But at the same time, the interpretation of the arbitration clause is done narrowly by the court. So the court is not in favor of broadening the interpretation of the arbitration clause. And I think this is related to the constitutional rights of the people, that they have the right to go to court, unless they expressly agree on arbitration. So you see that the arbitration in UAE is an alternative dispute resolution. Since it is not the default dispute resolution mechanism, it is an alternative one. The court is not in favor of broadening the interpretation of the arbitration clause. So arbitration clause must be clear and must reflect the actual will of the parties to refer the case to arbitration, and it must be clear, otherwise it will not. Now, for example, and recently there was a case on what's known as optional arbitration. Optional arbitration. So the arbitration clause was there, it was valid, but there was a sentence in the arbitration clause which says that the dispute will be referred to arbitration if the parties agree on it. So basically, and they did not. Later, one of them went to the court. So basically, this is called an optional arbitration clause. If it's an optional arbitration clause, although it's valid, the court will not enforce it. The court will say that the person, it's optional. If the person chooses to go to arbitration, it's okay. If parties agree to go to arbitration, it's okay. If they do not want, or one of them doesn't want, then they will have to come to court. Actually, the court missed the opportunity. I would say that in such cases, it is good for the cassation court to grab the opportunity to explain the law. This will help us as arbitrators, will help lawyers will help the legal society. Actually, it missed the opportunity to comment on what's called unilateral optional arbitration. Is that it's optional for one party and it's compulsory on the other party. So that was still vague and still controversial.
Yeah. So whilst we're
yes.
no, I was just wondering that whilst we're talking about enforceability and supervision of national courts, and without wanting to go back too much to the decree, will that have any effect? Does the decree have any effect in relation to which court supervises the arbitration?
Yes, it depends on the applicable arbitration law. This will be linked to the applicable arbitration law. As I said, the decree has an effect on the applicable arbitration law when the arbitration clause is silent on the applicable arbitration law. Then in this case, the DIFC arbitration law. In this case, in the DIFC courts, we will have the jurisdiction. Whether with regards to the challenge of arbitration award or even challenging arbitrators. But of course, in the act, then you will have now the court. The court where you can, it's replacing the executive committee where you can challenge the appointment arbitrator there as well. So back to my point, which I think it's an interesting question that you raised, Sam, is whether the court may deny the enforceability of a valid arbitration clause. Let me just mention a recent case where the court refused to enforce an arbitration clause. It was called in the interest of justice. In the interest of justice. It's a very interesting case. A case where an employer sued the contractor and the engineer. So in the construction contract, there was an arbitration clause. But, in the construction contract, there was no arbitration clause. In the consultancy agreement with the engineer, there was a valid arbitration clause. So the consultant, the engineer, objected to the jurisdiction of the court, saying that, well, we have a valid arbitration clause, then the court doesn't have jurisdiction, we need to refer the case to arbitration. The case went up to the Court of Cassation, and actually the Court of Cassation decided that in the interest of justice, it is better for this case to be reviewed by the court against both the engineer and the contractor to avoid any contradictory decisions, because the decision, the issue or the dispute linked between the engineer and the contractor. So this is an example, for example, where the court may deny the enforceability of the arbitration clause in the interest of justice. Of course, there are other areas where, for example, the arbitrable dispute or the non-arbitrable dispute, I should say. For example, if the dispute is about a public order issue, then it's not arbitrable. It's not arbitrable. And we have examples. So the court, of course, will not accept any objection to its jurisdiction when the dispute is about a public order issue or the scope of the dispute. The scope of the dispute, it's true, you may have a valid arbitration clause, but it is limited. And the disputed issue is beyond the scope of the arbitration clause. In this case, of course, the court will decide that it has jurisdiction to continue on the case. So they are cases, but as a principle, as the default answer of the principle, the court will enforce the valid arbitration clause in the normal circumstance. All these are just exceptions. I think.
Just to add, thank you, Hassan. I just need to add one idea that will summarize what was mentioned by my colleague.
Sure.
Is that there is no relation between the validity of the clause and the validity of the award. Okay, you might have a valid arbitration clause. Okay, and then something happens. Okay, at a later stage that is not related to the clause itself. Okay, that might lead to the nullification of the award. So in this case, if the court decides that there is something missing in the award itself, I mean procedure-wise and not the essence of the law, unlike judicial courts. In this case, despite the fact that the arbitration clause is valid, but still the award cannot be enforced. No? So we need to distinguish between the validity of the clause and the validity of the award. Now, the validity of the award is related to the validity of the clause, but the opposite must be.
Yeah, of course. Yeah, no, thank you very much for that. I mean, we're going to talk about fairness in the context of public interest and natural justice in a few seconds. But one thing I just wanted to cover finally with you, Professor, was signatures, because I've seen this talked about quite often, that in terms of signatures and terms and references, is it enough for the terms of reference to be signed by counsel of the parties, for instance, without the need for the signatures of the parties themselves?
Thank you, Sam. Actually, I would say that all these questions are related somehow to recent cases in UAE. I would say that usually the power of attorney of the councils will authorize them to sign the terms of reference, but not always. Not always. Example, legal fees, attorney fees. Now, attorney fees, if the power of attorney of the council does not include express authority, not apply, express authority to the council to agree on the legal fees and attorney fees, then the tribunal will not have then the lawyer or the council will not be able to sign the terms of reference if it includes an agreement on the legal fees. So I see different. No, we're talking about So I see it depends, of course, on the applicable arbitration rules. So we need to be careful here if we're talking about, for example, the current DIA rules do not have any term that authorizes the tribunal to decide on the attorney fees, on the legal fees. Okay, I'm repeating myself, attorney fees, legal fees, because we have a case where the court rejected to interpret the term legal fees to mean attorney fees. So it's better even to call it attorney fees rather than lawyer fees, or we put,
and we have to think also between fees and expenses.
Exactly, expenses will be fine. Expenses will be fine if we're talking about the arbitration cost, arbitration expenses,
arbitrators' fees.
Arbitrators' fees, even the cost of arbitration, hiring an expert, the venue of arbitration, that's fine. This is within the authority, within the jurisdiction of the tribunal body. No need for the parties to agree on this. But what's needed is their agreement on the power of the arbitrator to decide on the attorney fees. And this is very important because sometimes, and actually not sometimes, in most cases I've been involved in, is that the lawyers do not have, the counsel do not have the power to agree on the attorney fees because their power of attorney does not include this authority expressly. And what's needed is the express authority, and this is the approach of the UAE court. So in this case, I would say that if we include in the terms of reference the authority of the tribunal to decide on attorney fees, then better you get the terms of reference to be signed by the parties themselves. And maybe the council, but there's no need. Once the parties sign, that this will be more than enough. So you need, but be careful as well when who will sign the parties. So if it's a limited liability company, you need also the general manager to sign the terms of reference. One other example where you need also the terms of reference to be signed by the parties themselves is that if the council the council of the parties agree on something that's contrary to what is there in the arbitration clause. For example, suppose that the arbitration clause does not mention or mentions that the language of arbitration is Arab. And the council found out that it will be easier for them or will shorten the period of arbitration, will assist the tribunal to agree to conduct the arbitration in English because the contract is in English, the correspondence is in English, and others. So in this case, if they agree that to conduct the arbitration in English, that means they are like amending the arbitration clause, which is not allowed, they are not authorized to do so. Now, in this case, the tribunal will ask for the signature of the parties themselves rather than the counsel of the parties in the such case. In general, I would put in a brief, generally speaking, the counsel, the lawyers, will be authorized to sign the terms of reference. However, in certain circumstances, the tribunal must be careful. The arbitrator will need to ask the counsels to get back to the parties themselves to sign the terms of reference.
We are facing this.
Yeah.
Another arbitration, we have a case,
Yeah.
and we are asking the parties to explicitly agree on us deciding on the fees. Otherwise, we cannot decide on the fees.
And one thing, Sam, about this, by the way, it is one of the duties of the tribunal is to protect the award. By the way, it's a duty. It's a duty. One of the duties to protect the award. So this is one of their duties to make sure that the award is valid, and the final award that they will issue is valid, enforceable, and cannot be challenged. There is no defect in the award. And this is one important issue. If, for example, if about the language, if they go on with the language to be English, despite that the arbitration clause says that the arbitration must be conducted in Arabic, then the parties themselves can say, one of the parties may eventually say that, well, I will not authorize the council to agree to change the language. So that's something that we need to face this issue.
Yeah. So basically, check the document you're signing to check if you have authority.
All cases ask the original parties to sign the terms of reference.
Yeah.
And have
Great.
a
Great.
Yeah.
That's absolutely fantastic. Thank you. What I'll do, Professor, is I'll come back to you just in a few moments with some questions which have been raised by our participants or our individuals who are with us today virtually. But Doctor, if I can come to you, because I wanted to talk to you about fairness and arbitration and this kind of idea of of natural justice. But before we talk about those things in any particular detail, one thing that's kind of always been spoken about, at least some my colleagues to me, is whether there's an obligation on an arbitrator to protect, for instance, a party from making its own mistakes or its own failures, or even mistakes about their strategy. Do you think the arbitrator has a duty to protect the party from doing wrong things?
Again, good evening or good afternoon for you, Sam, and for all the esteemed attendees. And I thank Professor Aymen for his kind invitation to participate in this lovely seminar at this esteemed establishment, the British University. Now, regarding your question, Sam, let us at the beginning talk a little bit about fairness in general. And to emphasize on the fact that fairness was served sufficiently by the imposition of a variety of duties and obligations on and limitations, of course, on arbitrators. Such limitations can be found either in a certain legal framework, a regulatory framework, or the contract itself. Now, if we want to talk about legal framework or regulatory frameworks, we can talk, for example, about many rules that are existing nowadays, and they talk about such a principle. For example, if we talk about the municipal arbitration law that talks explicitly in its Article 18 about the model law about the principle of fairness in arbitration. The same principle was mentioned also in the margin Article 24, whenever where it talked about oral hearings in which parties can submit their case in a fair and equitable manner. Likewise, for Article 26.2, for example, of the UAE rules that talks about calling for experts and cross-examination, and this is the right that is open for everybody. So all these issues, they fall under the title of what we call the principle of due process, okay, that should be usually respected mainly by the arbitral tribunal to give the parties the right to present and defend their case in a fair and equitable manner. The same the same principles were mentioned also by domestic laws, like, for example, the England Act of 1950 on arbitration, that talks also about the principle of natural justice. Okay, that implies what we call fairness and equity. In the USA, many laws are at hand or applicable, and most of them, they talk about the right to be heard. And this right to be heard is given usually to all the parties. And it falls underneath this issue many subdivisions, like, for example, whenever we have hearings, the issue of cross-examination about for the parties and the counsel, etc. Now, going back to your question, the question is, can the arbitrator, protect a party from its own failure? Because of the things we mentioned, and mainly the issue of due process that is given to each and every party to present its case, defend itself, say whatever they want to say, in writing, orally, depending on the circumstances, of course, then we don't need the arbitrator to interfere to provide such a right. He is already the arbitrator providing such a right, by giving the parties the right to be heard in an equitable manner. Now, if the arbitrator's obligation is to protect one of the parties from its own failure, in my modest opinion, no. There are no obligations on arbitrator to perform such a task, because such a task is given usually to counsel. So it's up to you to present your case, and if you are not up to it, then this is your problem. And this principle was applied in courts. Like, for example, the Supreme Court of Victoria in Australia, in the case of Full Joy Food versus Australian Dairy Park, mentions that there are no obligations on the arbitrator to protect any of the parties, or not only to protect, even to give them guidance also to be protected in a rightful manner. The thing, Sam, that does not apply in mediation, because arbitration is like you are rendering an award, while mediation, you are helping them to reach a settlement. So the concept is somehow different.
Right. So, when an arbitrator sees a party making a terrible mistake, there's no obligation on the arbitrator to prevent that from happening. But obviously, there's an obligation on the arbitrator to make sure that.
Unlike judicial courts, for example,
Yes.
Like, for example, in the IFC courts, they apply English law, they have a duty, judges sitting in the IFC court, to guide the parties, not on the merits of the case, but on the process and procedure.
Yeah. Super. So, when we're talking about natural justice and sometimes the pursuit of justice, do you think those terms are outdated for arbitration? Because, the arbitration has well-established processes that guarantee a lot of fairness. So, do you think, they're outdated, or arbitration's done enough and has enough to keep things fair?
To answer the question, I will speak about it in a different way. If, for example, you have a court judgment that you need to oppose or appeal or go to the Supreme Court, the court will view the case on the merits and procedures. While if you are talking arbitration, courts have no right to interfere on the merits. They talk only about procedures and whether these procedures were done in a proper way or not. And usually there are 5 conditions, mainly those mentioned in domestic law and in the New York Convention of 1950. So yes and no. Likewise, that I mentioned before about domestic laws, like the 1950 arbitration law in the UK. Talks about the principle of natural justice. And in other jurisdictions, it was mentioned, but in a direct way. So it's up to the arbitrator himself to evoke this principle and to protect the issue of due process, to guarantee that the award can be enforced in a proper way at a later stage. Because the only defect that might be viewed by a court is something related to procedures and not to anything else.
Right. Okay. So we were talking before with the professor about terms of references and having the power for lawyers to sign certain documents. But in terms of the arbitrator, does the arbitrator have a power, for instance, to modify the agreement of the parties?
Me?
Yeah.
Okay.
Yeah.
Actually, this is a very interesting question. Again, I would like to start with the general principle.
Yeah.
It says that contracts are sacred and binding. Pacta sunt servanda et Latin formula. So the principle of relativity, contract was drafted by the parties. It cannot be amended unless done through by the parties. Good. Okay. So this is the general principle that governs contracts that we all know and we are all aware of. However, we have exceptions. And such exceptions are many. I will mention some of them. For example, if we talk about arbitration or the special type of arbitration that we call ex equo e bono, okay, which means in French l'arbitre amiable compositeur, or in Arabic we call it at-tahkim al-mutlaq. Okay, so in such a case, okay, by definition, the arbitrator is given the right to overcome any existing law that can be applicable to the dispute. And they apply the principles of fairness and equity. So this is, and this is the backbone of fairness and equity that is usually applied by such type of arbitrator. Although I find it personally a bit dangerous to give the arbitrator.
Is it common?
It's not very common. Not very common, especially nowadays because we have many institutional rules that are being enacted.
Exactly.
So why like give our neck to the arbitrator, for example, although this guy will be entrusted with the case, and we talked earlier this morning in the presence of Professor Aymen about multiple nomination, disclosures, and so on. And the credibility of the arbitrator is extremely important. Its reputation is extremely important. But we cannot give the arbitrator, in my opinion, although I'm an arbitrator, but I refuse to do it usually as an ex equo e bono because it's somehow dangerous. Okay?
Yes.
Now, in such type of arbitration, you might be given the right to do so, but such an issue must be given to you explicitly in the agreement itself. Okay. Now, on the other side, we have domestic laws, okay, that allow us, whether we are judges or arbitrators, to modify the agreement. And mainly, whenever we talk about American laws, and specifically, I'll talk about the Uniform Commercial Code and the Unidroit rules, okay, whom are guidance, unless agreed upon by the parties, that also talk about a very important theory in contract that we call the theory of hardship. So whenever we have a case of hardship, okay, which is different from the case of force majeure, then whether we are talking about the judge or the arbitrator, but it's a bit tricky with the arbitrators, judges, they are entitled by law to modify the agreement and to adjust the agreement and to adapt the agreement so it can go up to the current economic situation. Okay. Now the debate is still ongoing to see whether this power, this authority that is given to the judicial judge, whether it can be used by the arbitrator and specifically by the ex equo e bono arbitrator, yes or no. Okay. In my opinion, yes. In my opinion, yes. Why? Because arbitration is an ADR, alternative dispute resolution process.
Yeah.
So it's judicial court. So all the powers that are given to judicial judges should be given to arbitrators in order to render their award in this case or not. Okay. In this regard, something happened to me which was funny. And allow me not to mention details because it's a case in which I was sitting as a sole arbitrator. Okay. The agreement says that, for example, arbitration talks about the sea, the applicable law, and the language of arbitration. The language. And it mentioned explicitly that the language in such a case is English. But in due course, one of the parties sent me a letter saying, we are Arabs. You as an arbitrator, you are an Arab. The other lawyer is an Arab, so you know Arabic. We are in this Arabic country. we apply, for example, Islamic law, etc., everything in Arabic, so the proceeding should be in Arabic. Am I entitled to do so without having the explicit acceptance of the other party? Definitely not.
Absolutely.
Okay, so this is one example about when you can interfere to modify the agreement and when you cannot.
Okay, so when things go badly wrong and then a party takes that awards and challenges it to a domestic court, is there some themes internationally that the domestic courts use to determine whether or not to set aside an award because of a breach of natural justice?
No,
Can you repeat please, Sam, the question?
Yeah, so I mean, when a court considers an application to set aside an award based on a breach of natural justice, what do you think the court considers, and what in your experience has the court considered?
Again, I will repeat what I mentioned earlier today.
Yeah.
Say that courts, whenever they are looking at the validity of an award, they can look only upon they can focus only on procedures. Okay, they cannot look. They don't have the authority to discuss the merits. And once we say natural justice, it means merits. In my opinion, some people they say that no, natural justice is the due process or the procedures. Yeah, yes, but this is the only case, in my opinion. Otherwise, they cannot.
May I comment here, Sam?
Yeah, of course.
Very interesting. Yeah, actually, we don't have a clear-cut rules or guidelines, if you like, on this matter. I know in some jurisdictions the court provide guidelines, but I would say if the matter is related to due process or it's related to procedures, and the court found out that there is no link between the breach of due process and the outcome of the arbitration case. So the award itself was not affected by the fault of the arbitrator, if you like. In this case, I would say that the arbitration award will stand. I will not be set aside. So basically, as a lawyer, if you want to challenge the award on the ground of due process or lack of regularity of procedures, you need to prove that this problem, this lack of regularity of procedures or due process, in this case, it affected the outcome of the case, the award. And if the court is not convinced that the award would be different if the arbitrator did not commit such a fault, in this case, the most likely, I would say, I'm pretty confident that the court will not set aside the award.
Yeah, and I think that's been my experience. I mean, depending on the jurisdiction, that the court wants a connection, as you were saying, between the proposed or the alleged failure of natural justice and that actually making a difference to the award. And if there's no difference, then go away. Pretty much is what I've seen.
Actually, which makes sense. Yeah. At the end of the day, the arbitrator may commit a fault, may, without intending to do so, breach natural justice or not observe or correctly observe the due process. But if this did not affect the outcome of the arbitration, it did not affect the award. So the award will be the same. Even if he did not commit a fault, then of course the award will stand and will not be satisfied.
Again, to concur with my colleague here, natural justice is a general principle of law. Okay, that is not codified. But and in recent developments, not very recent, the reasons that are used or applied by courts to set aside an award, again, are procedural methods. Okay, including this part, which is the due process issue. So we have 5 reasons that are mentioned either by the New York Convention or by other domestic laws. For example, in Lebanon, Article 800 of the Code of Civil Procedures talks about those 5 reasons that can be used to set aside an award.
Grounds of challenge.
Grounds of challenge. That's why you cannot do it otherwise. Why? Because you are speculating, and you don't have something that is tangible, because it depends on the assessment of X, Y, or Z. We cannot use this because arbitration is about credibility. Okay, you need to at least know the outcome of a case if it goes in this or that direction. You cannot leave it to future and uncertain events.
Yeah. Well, one of the questions that's been raised by one of our participants today is that what are the grounds for the legal grounds, for the arbitrator being able to modify an arbitration clause, taking into account that obviously the constitution of the arbitration is set by the parties, and that you then the arbitrator then has to comply with it. So, I mean, are there legal grounds for the arbitrator to modify the arbitration clause?
Arbitration clause is something that you cannot, because it has to be done in writing.
Yeah. Yeah, I mean,
you cannot modify it unless you do it in writing.
I think he's referring to what you said, that when the arbitration clause allows
yes,
the arbitrator.
Because no, in this case, the right was given explicitly to the arbitrator to do that. Otherwise, you cannot. Again, relativity.
Yeah, absolutely. And I think.
And this is not related to hardship or anything else, to protect the parties or to the system or economy. Okay.
Yeah.
No, there's something very specific to the agreement itself.
Yes. Yeah.
I remember. It's so interesting. I remember I was sole arbitrator in a case where the counsel, the lawyers were not experts in English law. So the applicable law in that case was English law. And in the preliminary meeting, while we were talking about the terms of reference, then both of them said that, look, Professor, we need to change the applicable law. How can you change the applicable law? It's there in the arbitration clause. Yeah, of course. This is what we did. Say that, told them, I don't think you can do that unless you go back to the general managers, they were limited liability companies, the partners. Go back to the parties, they then agree to change the applicable law to UAE law, and then we'll take it from there. So this is an example where sometimes the council does not observe or does not observe the arbitration clause. And
I want to add up one idea to what you mentioned.
Yes, please.
The arbitration clause was signed by the parties and not by the council.
Yes.
Okay. So modifying the arbitration clause should be done by the parties, not by the council.
Yeah.
Unless again and again and again they were given the right to do so explicitly, either in the power of attorney or in any other supporting document. So what mentioned by Dr. Aymen is true 100%.
Yeah, I mean, the power has to be given, doesn't it? In the actual agreement.
Who didn't get revoke or change it.
Yeah. I mean, I remember seeing one case, this is some time ago, when there was about 10 parties to one agreement, and there was a provision given for the arbitrator to be able to modify something, but only if 7 out of 10 of the parties agreed. And there was, things going on which, behind the scenes to get other parties to agree. But yeah, I mean, it's all about the agreement, right? One of the other questions that's come by, which is about the decree, and I asked both of you this question, is that if Professor's the expert on this. The question is that if an arbitration agreement has been made under parties after the decree of merging the Maritime Arbitration Centre and DIAC, will the arbitration clause be valid? And will DIAC have jurisdiction of the case, or will the clause be invalid? I think you've perhaps answered that question before.
Yeah. Just to be straightforward here, if this agreement happened after the decree came into force, that was, I think, 20th of last September, then this agreement is invalid, and you risk the arbitration clause here. The arbitration clause, all of the arbitration clause will be invalid in this case, and you will end in the court. Unless, of course, at any time the parties agree to refer the case to arbitration under the Act. I mean,
unanimously.
arbitration agreements not necessarily to be included in the original contract. They can have a submission agreement. They can have a separate agreement. Even after the dispute arises, the both parties can agree to refer the dispute to any arbitration center level.
Which brings us back to the difference between the arbitration clause and the arbitration agreement. The arbitration clause, it happens before.
Yeah.
The arbitration agreement, it happens after.
Yeah. Yeah, that's a really important distinction, isn't it? I mean, just staying on the decree, one of the other questions was the other way around to most questions, which is what happens if you had an existing case proceeding under DIAC rules? Will the seat of arbitration now change to DIFC?
It's the opposite. It's the opposite.
Yeah, which is an interesting question. So you're saying that there is an ongoing case under the DIAC rule.
Yeah.
Under MCIA rule. That is the example, and then you say that you send it to DIAC because it's our case now. Because everything is from all arbitration centers to DIAC. So DIAC will be in charge now.
Yeah, no, the question that was asked was if you had an existing case under DIAC, will the seat of arbitration now change to DIFC? And I think
I know why this question is asked. I think this will be related or in the mind of the person who's asking the question is think about the case where the arbitration clause is silent on the applicable arbitration law or the place of arbitration or the seat, let's say the applicable arbitration law or seat. So in this case, because under the new decree, if the arbitration clause is silent on the seat or arbitration law, then the DIFC arbitration law will be applicable. Now, in other cases where the arbitration clause says that the arbitration is in Dubai or the applicable arbitration law is the UAE arbitration law, straightforward, then the arbitration law will continue to apply with the rules. I would say some, although the decree did not really explicitly touch on this, I would say that once the arbitration application is filed and the applicable law is the federal law, the federal arbitration law, it will continue to act. It will continue to govern the arbitration case, even the ongoing cases in the act, even if the arbitration clause in such cases is silent on the seat or the place of arbitration. So basically, it will not move, will not switch to the IFC arbitration law, it will stay as it is because the case is ongoing. So I don't think that the decree will have any effect on the ongoing cases with regards to the applicable arbitration law.
And add up to what the professor mentions, okay? And to reverse the example, if the case was under the MCIA, okay, and the seat was the DIFC, okay, then after the decree, what happened? The management of the case only was now falls under DIAC, but still the rules of MCIA and the seat and the applicable law remain the same, because otherwise we go back to the question you asked me: can the arbitrator modify the arbitration clause or the arbitration agreement? Definitely not, unless you have it or do in exceptional circumstances. Okay? So this is something to add up to what my colleague mentioned. Absolutely.
And I've got a connected question there about what the arbitrator can do and his or her powers. And especially, this is quite relevant to what's been going on in the last 18 months. But can a tribunal have the ability to order remote hearings against the wish of parties? Now, I've actually had this several times at the beginning of COVID, when a lot of parties, for whatever reasons, said, no, we've got to stop everything. Let's stop everything for 6 months and let's come back. I've seen it done in different ways. But what do you both think? I mean, do you think a tribunal can order a remote hearing to take place if it can be done fairly, which is the kind of test that I've looked at?
I'd like to say that ICC recently issued a special note on conducting hearings in during court that gives explicitly the right to tribunals to do the hearings remotely.
Yeah.
But talking about safety here. So yes, they can, in my opinion.
Yeah. I mean, my experience has been, unless there are good grounds which show that it can't fairly be done, then
and things are being modified nowadays to fit this purpose also.
Yeah. And you know,
I would say that the main problem is that when both parties agree, if we have a case where one party is improve the use of technology and the other party is against, this is not a problem under UAE law, because UAE law is clearly authorizing the tribunal to use technology. So to conduct the hearing, even for the cross-examination of witnesses, not to be in the same place.
Although they recommend to do so.
So there's no problem with this. But the problem is if both parties agree not to use technology. So this will be really a problem.
Yeah.
I don't think that I don't think that tribunal and the UAE law will be able.
He can decide by himself, unless what you mentioned happened.
Yeah.
Exactly. So when you know what about arbitration at the end of the day is different from litigation in the sense that the parties have power on the procedures.
Yeah.
They clear the case to arbitration. They don't have power on the outcome at all, of course. That is for the tribunal to decide. But when it comes to the procedures, they can agree.
Yeah, but let me ask you this, because I was having a discussion. It's been going on for quite a while now with some very experienced arbitrators, and when we've been sitting in panels, some of them have said, especially with construction cases, when when you're hearing evidence from engineers, that when they've heard the evidence remotely from engineers, that their evidence is more authentic, because you're not with the group of lawyers all the time, and it's kind of you're not bombarded with your legal. And I found that a very interesting insight. That there's, because I mean some of them, and one of them recently was insistent. Listen, we should have this continue this evidence remotely because we've already started, number one, but also it's quite complicated, number two, but also it's quite good to have them separate from their legal team sometimes. But I mean you don't have to say anything about those observations, but it's quite an interesting observation that I've heard a few times from very experienced arbitrators when I sat in panels.
Yeah.
And the other thing which I've seen very recently, as I said before, is the use of witness evidence boxes. So you actually have a room where the witness goes into, and they have cameras dotted around the entire room, so the arbitrator can actually see the body language of the individual.
I like this because one of the main challenges that we face when we hear a testimony, we don't know who's sitting next to him, or is
whether he's alone in the room or somebody else
taking the answers, or so whether he was alone in the room. So having this kind of cameras in the room may help. It is not really 100% thing that to make sure that he's alone, but it helps a lot actually that no one is sitting next to him or giving him the answer.
Let me add up also. I always add up because he's a professor.
I know. You're the boss.
The question is it possible? Yes, it is.
Yeah.
Is it recommended? No, it's not, in my opinion. Okay. That's why in the recent case, we were doing a cross-examination of one of the witnesses, and we made them sign, or we made them make sure that he's sitting alone in the room. Are you alone in the room? Now, some people, they try to tell them to rotate the cameras. It's not appropriate to stay. But yes, we can ask this question. And later on, if it can be proven, but you are giving here room for challenging the award in case one of the parties can prove, no, he wasn't alone in the room.
Yeah.
So that's why I always recommend to do it in person.
Yes.
Because of these issues and because of the main issue of body language. Okay.
Yeah.
With the eye, it's different. His screen having his coffee or wearing his shorts.
Yeah. Yeah, no, I entirely agree with that. I think there's, for when we sit as arbitrators, it's so important to determine what we call credibility, the demeanor. Yeah, no, absolutely. Well, thank you. I think I've dealt with most questions which have come through from our participants and from those attending. So thank you very much. I'd like to take this opportunity to thank you, Professor and Doctor, for being in conversation with me. I've really actually enjoyed it. It's felt like we're in the same room, but we're not. I sadly can't be in Dubai this week, but I'm in Dubai next week. So, Professor, I'm sure I'll see you next week. But thank you very much, both of you, for your very insightful and detailed responses to my questions. And thank you to our audience. I know this is the first day of the beginning of the Dubai Arbitration Week. And I'm sure it'll be a very, very interesting week, as it is in all years. And it's always a great opportunity for everyone to get together and see lots of people. And this year, that's more important than other years. But thank you very much for attending. And thank you again, Professor. And thank you again, Doctor.
Thank you very much.
Thank you.
Bye-bye.